Welcome back to This Week in Immigration. I'm Jordan LaPier. On the program this week, the Trump administration seeks to cut refugee admissions, new asylum cooperation agreements with El Salvador and Honduras, and we debut Litigation Corner with a look at the latest legal happenings. All that's just ahead. But before we get started, please remember you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. And if you leave a review, it'll help more people find our show. You can also stream This Week in Immigration on our website at bipartisanpolicy.org/podcasts. And as always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. And here with me today are Theresa Cardinal Brown, Director of Immigration and Cross-Border Policy. She's on Twitter at BPC_T Brown. Hi, Theresa.
Hi, Jordan.
And Cris Ramón, Senior Immigration Policy Analyst. He's on Twitter at CRamonBPC. Hey, Cris.
Hey, Jordan. How's it going?
Great. Let's start today with news the Trump administration is seeking a dramatic and controversial cut in the number of refugees that can be admitted to the United States next year. The administration has set a proposed cap of 18,000 refugees, which would be the lowest number in 40 years. They also unveiled an executive order seeking to allow states and cities to reject the resettlement of refugees in their areas. How significant a departure is this proposed cap from past limits?
Well, as you mentioned, this is the lowest cap that we've had since the Immigration Act of 1990, which first put in place the refugee cap system. And it would be the lowest number of refugees we have admitted in about 40 years. It's interesting to note that the cap this year was actually set at about 35,000, but actual admissions this past year were about half of that. So the cap is just that. It is a maximum number, but based on the limitations that the administration has set on the processing and the delays that have been implemented, we may not actually admit even that many. Some details about the cap. The 18,000 is an overall cap, but there are subcaps within that. In previous years, each region of the world has had a subcap. Of interest this year is that there's been a set aside of 4,000 visas of the 18,000 for individuals who are suffering religious persecution. That is a first that I'm aware of, where there's been a set aside based on a specific criteria of refugee status. Other things to be aware is that there's a slight increase in the refugee numbers from Central America. So if we do more processing of refugees in Central America, there would be a slightly increased number. I think it's about 1,800 from that area. So there's been some tweaks to that, but the primary news is the significant reduction overall. And this has implications for our refugee processing apparatus, the number of government officials and the government agencies that process that. But more importantly, we partner with non-governmental organizations across the United States that actually do the resettlement of refugees who have been approved in communities across the country. They rely on government funding passed through the states to support those refugees through their first year with housing assistance, job finding assistance, language assistance, getting their kids enrolled to school, all of those things to help refugees integrate into the country as rapidly as possible. All of those agencies are reducing staff, cutting programs. So our capacity in the future, if we want to increase the number again, will be significantly limited. So this is going to have a serious impact on our ability to process refugees for a long time to come, not just this year.
I think the best way I described it on Twitter is like you're destroying a coral reef. And coral reefs sometimes don't grow back to the same size that they were before.
Yeah, it's a hard thing to think about. The other thing that's worth noting is that for the longest time, the United States has admitted more refugees than any other country in the world. And we have used that to basically coerce or convince or sometimes shame other countries into also accepting refugees. And by pulling back the way we are, we limit our ability to encourage other countries to actually accept refugees. They look to us and say, well, if the United States isn't taking people, why should we? And so we are at a time when there are more displaced persons in the world than pretty much any time in history who are seeking refugee status somewhere in the world. So this is an inopportune time, if you look at it from that way, to reduce the number of refugees coming in. It's also worth noting that Ken Cuccinelli, the acting director of U.S. Citizenship and Immigration Services, when he was talking about this, talked about this in terms of what we're seeing at the U.S.-Mexico border in terms of the increase in asylum cases as offsetting some of the refugee cap. This is a new argument. Never before has the government somehow said that because we're seeing an increased number of asylum applications, we're going to reduce the number of people we're going to resettle from overseas. Yes, it is asylum officers and refugee officers from USCIS that do both sets of adjudications, but it's not necessarily robbing Peter to pay Paul. They do operate in different areas of the world, so it doesn't have to be an offset. This administration is choosing to think of it that way.
Let's take a little moment here to do some educating for our listeners. The differences between the asylum program and the refugee program.
Sure. Let's get back over that. Thank you. So the difference between a refugee and asylee primarily is where they apply. A refugee is somebody who has been forced out of their country and under the international conventions can gain refugee status if they are persecuted or have a well-founded fear of persecution on account of one of the 5 recognized areas, which is race, religion, nationality, political opinion, or membership in a particular social group. If you go through a process overseas, you're in a refugee camp somewhere in the world outside of your country, and you go through the UN High Commissioner on Refugees, which vets you and then refers you to the United States or another country for refugee resettlement. The United States then processes you through our system and does all of those checks while you are overseas, and only after you are approved are you resettled in the United States. Refugees are entitled to all of those supports I mentioned, the help finding jobs and places to live and all of that kind of stuff. An asylum seeker is somebody who arrives into a country, into the United States, and then seeks protection. They have not gone through any of that process overseas. They just arrive at our border and say, hey, I'm afraid. I'm being persecuted. I want protection. At that point, the United States has to do all of those checks of them after they're already here, decides whether or not they qualify under the same conditions, persecution or well-founded fear, and if so, grants them asylum status in the United States. In the United States, an asylum seeker is not entitled to all of those same benefits that a refugee gets. They're kind of more on their own. But after a year, both a refugee and an asylee can apply for permanent residence in the United States. So the main difference between refugees and asylees is where they apply. The standards to come and get that status are the same no matter where you apply.
All right, so coming back to the issue at hand, how does this limit of 18,000 fit into the administration's priorities for the refugee program specifically and for the immigration system more broadly?
Basically, what you've been seeing over the last couple of years is the administration has increasingly decreased the number of individuals, the caps for refugees. And largely, this, I think, is aligned with the fact that they've been trying to limit legal migration. We've heard from reporting, for instance, that, obviously Stephen Miller, who plays an important role in the Trump administration, has been adamant about reducing the numbers of refugees. They kind of have seen this as a national security issue, especially in the lead up in the 2016 presidential election, that they want to reduce the numbers of refugees arriving because they see them as a national security threat. Now, regardless of whether somebody agrees with these positions, that's what the administration has been doing. So I think this falls in line with what they're doing. It falls in line with their broader priorities with trying to deter the arrivals of asylum seekers at the U.S.-Mexico border, for instance, and tightening up the legal migration system. So I think it lines up more or less with what they've been trying to do with lawful admissions into this country through different streams that we have for entering the country.
So let's break down this new executive order, the other piece of what I talked about at the top of this segment. How would that work, and what kind of impact would it have on the U.S. refugee program?
I think that there's going to be potential that this new executive order could reduce the numbers of refugees where they're being settled across the country. So why is that? So first of all, the executive order. The executive order instructs the Director of U.S. Health and Human Services, which oversees the refugee program, to come up with a protocol that would allow them to basically sit down with state and localities to determine whether or not that state and locality wants to accept refugees. The core thing about this EO is that the state and the locality have to agree. It can't be the state saying we want refugees, and it can't be the locality saying we want refugees. They both have to agree in order to do that. If they agree, then refugees can be moved there according to the process that's going to be developed. If they don't agree or they don't say anything, then refugees will not be settled there. Now, why is this potentially something that could reduce the numbers of refugees that are being settled across the country? Maybe not an overall number, but where they're going to be distributed. If you remember around 2016, at the height of the European refugee crisis, and you sort of saw the unfortunate terror attacks in Paris and in other parts of France and part of Europe, this whole notion about refugees, which was actually being mixed up with people thinking about asylum seekers, which we've kind of described that. People started in the United States started worrying that the arrivals of refugees would pose a national security threat, that these individuals might be terrorists, that might be aligned with, for instance, ISIS and other terrorist organizations. And so what you started seeing across states and localities, to be honest, among more Republican-leaning states and localities, that they didn't want to resettle refugees through the refugee program. They didn't want them because of the national security threat. There were several lawsuits over this issue. It didn't really have that much of an implication because really nothing could be done legally. But now this new executive order potentially could set up a way that these localities that have always maybe become more resistant to this issue in recent years might be able to stop the settlement of refugees in those areas. So I think it could have a potentially big impact on the U.S. refugee program.
Yeah, I would just add to that, what Cris said about the history of that is true, that even though refugees are processed through all the security checks overseas, they're processed more security checks than anybody who arrives in the United States, any other group. There was this pervading fear. It's actually interesting to note that Vice President Pence, when he was governor of Indiana, signed a declaration that Indiana would not accept Syrian refugees. There was a lawsuit over that. The court stopped that order, saying you can't pick out a particular nationality. It's also worth noting that the law requires that the Refugee Resettlement Agency of HHS consult with states and localities before settling people in those localities, but does not give them a veto over doing that. This executive order would give a veto, but it's also in the law that the settlement of refugees cannot be discriminatory in any way. So, for example, if a jurisdiction says, I'm willing to resettle refugees from one country but not from another country, that may violate that portion of law. So it's going to be very interesting to see, one, what kind of process HHS comes up with that would not violate these other sections of law, would not actually give localities the veto, but would implement this EO. I think there's already a lawsuit being lined up over the executive order itself. So again, we may put this into our litigation corner in a future podcast, but stay tuned for this one because I think this is a definitely a new wrinkle. As Cris said, it probably would significantly reduce the number of refugees resettled because you have a lot of states where the state government and various localities may think very differently about immigration.
Okay, on the other side of the break, the Trump administration inks 2 new bilateral asylum agreements. Late last month, the Trump administration signed 2 new asylum cooperation agreements with El Salvador and Honduras, continuing efforts to allow the U.S. government to return migrants seeking asylum here to these other countries for consideration there. Cris, walk us through what these agreements will do.
So basically, for a long time, and I mean, for folks who've been listening to me on this podcast, I've been describing these agreements as what I call first entry agreements, which is essentially a type of asylum management agreement between 2 or more countries, where the individual who enters into the country where the asylum seeker enters first is responsible for taking in this asylum seeker. After reviewing these deals, I think I've come to that conclusion that this is actually something new, and I've actually been kind of wrong with describing these agreements, or at least thinking about them. What I think these new agreements do, which is very distinct from other types of first entry agreements like the Safe Third Country Agreement between the U.S. and Canada or the Dublin III regulations in the EU, is it does this. An individual who enters through El Salvador on the way to the U.S.-Mexico border will arrive, and the United States can deny them asylum. What the agreement does, which is interesting, is it doesn't necessarily say El Salvador has to take in this asylum seeker. What it does, it gives the United States the option to send the asylum seeker back to El Salvador. And I think that this is like the unique mechanism, because the United States probably has the option of deporting the individual to their country of origin or potentially sending them to El Salvador. I think this is something that's very new. I don't think we've ever seen a first entry regime where what you're seeing is that the country that's kind of the core receiving country all of a sudden has the option of where to send them. The important caveat here is that we need to see the implementation plan, because Honduras apparently is a very similar agreement. These two are very parallel to each other, and I think what we need to see with the implementation plan is how the United States is going to decide which country takes in the asylum seeker. And I think that will flesh it out. But this is something that's very new. And look, I'm not above correcting myself. And I think that this is something that I think is new, and it makes it interesting from a policy perspective. But I think obviously will have important implications in the way that we're managing migration in the region.
Yeah. So the U.S. is calling these, and the other countries are calling these asylum agreements. But it's not really clear where the asylum process lies. As Cris mentioned, under the terms of these agreements, the United States does not have to accept the asylum claim of that person and can send them back somewhere. It's also not made explicit that the country their individual sent back to has to process an asylum claim. Although they talk about expanding asylum capacity, it still remains kind of up to the individual whether or not they'd apply for asylum there. But it puts the burden on that country that we send them back to figure it out. Will they process an asylum claim? Will they give them some other status? Or will they then deport them back to their home country? And the fact that we now have 3 agreements with Guatemala, El Salvador, and Honduras, it is very unclear how any of these agreements work together, because they all essentially say the same thing, but they're bilateral. So if we get an El Salvadoran, would we deport them back to Guatemala? If we get a Honduran who went through El Salvador first and then to Guatemala and then to Mexico, where do we send that Honduran? That's what's really unclear here at all on what decisions will be made. And again, we have to recognize that all of these countries are places where people are fleeing and seeking asylum from, and their own asylum capacity to grant asylum to other nationals in their territory is highly, highly, highly limited, in some cases almost non-existent. So again, I think an awful lot of these asylum agreements are more about the ability of the United States to deport people back to those countries, and they will accept them. And 2, there is an awful lot in these agreements about those own countries beefing up their own immigration enforcement regime and border regimes. And I think that has a lot to do with this as well. It seems very much like the United States is trying to create a cordon zone, and we're hearing that we're looking to do a similar agreement with Panama. So it's about preventing people from coming up from Latin America to the United States, having basically border enforcement checks throughout those countries that would make it difficult for people to go through. And if by some chance you make it to the border, guess what? We have the ability to send you back.
The way I would describe it is that whereas a safe third country agreement between the U.S. and Canada and the Dublin III regulation in Europe is a compulsory system where one party is compelled to actually take in the asylum seeker, this is what I'm now calling a denialist system, because it essentially allows the United States to deny asylum and then subsequently make a decision as to where they're going to deport the individual. So I think this is why I think it's something that's new.
Cris, the Trump administration first notched a win in this regard when it reached an agreement with the outgoing government in Guatemala. Theresa covered this a little bit by saying that the 3 agreements share a lot in common in terms of the language, but how do the 3 agreements compare as far as what we know about each of them?
More or less, I think they're cut from the same cloth as we've been describing, is that a lot of them really revolve around 2 core components, which is one, that the United States has the right to be able to deny asylum to an individual and then be able to return them back to the home country. When it comes back to the home country, the agreements there's no clear language of saying the country will then take the individual. This is why I'm saying it's not a compulsory agreement. It's just that the individual can be there. And then all of a sudden it's kind of like choose your own adventure, asylum edition. And so that's where that first component is. It's like, what's going to happen? The other important thing about this, and you're saying this more in the Salvadoran and Honduran agreement, which actually I should say the Honduran agreement hasn't been published. A lot of it right now has been secondhand reports from reporters, though is boosting asylum capacity, as Theresa said. That it seems that there is going to be a push to sort of strengthen the asylum systems in order to implement these agreements. But those are really the two core components of what we're seeing here. I think that the issue is, of course, is that it just hasn't been fleshed out. What we've been hearing is that the Trump administration is preparing a regulation for implementing safe third country agreements that will likely probably set up some protocols for being able to implement these agreements. But really right now, that's kind of the bare essence of these agreements. And I think they're not nearly as extensive because I don't think the protocols have been fleshed out.
Yeah, it'd be remiss if we didn't point out that all of these agreements have been signed, but none of them are in play. All of them require at least some sort of domestic process in the country. Remember, the Guatemalan agreement was held up in the Guatemalan Supreme Court for a little while, our constitutional court. These other agreements also have some domestic processes that have to go through. So they're not actually in place right now in terms of operationally implemented. But there's, as Cris mentioned, there's still a lot of questions about how that would all work even when they go into play.
We haven't even seen an English version of the Guatemalan agreement. We've only seen the Spanish language one. That should give you a sense of like what we're talking about here.
So how much of this new approach is based on the fact that these three countries simply can't commit to taking in asylum seekers and processing those applications?
I think the administration's hedging its bets, to be honest. I think the fact that these agreements are not compulsory, but they're denialist, I think is kind of the administration tacitly acknowledging that capacity continues to be an issue for these countries. And if you really set up a pure compulsory regime, you're going to deal with the capacity issues that hit the European Union during the beginning and the height of the European migration crisis. I've talked about this at length as to why capacity issues really made that problematic, which is basically if you don't have capacity and you get hit with a large arrivals of vulnerable populations seeking asylum, that's going to compound the problem. So I think this is the administration, maybe not necessarily the Trump administration, but DHS, which I think has been, to be honest, maybe a more honest broker on this, recognizing the limitations of trying to work with these countries to have them receive more asylum seekers. But I think really it is them kind of hedging their bets, and I think this is why the implementation plans are going to be key. Because for instance, are the implementation plans going to set a number of limits, caps on the number of people returned back to these countries, for instance? Are there going to be different caps for each of these countries? These are all things that need to be figured out, but I think they're proceeding cautiously, to say in the least.
It's also worth noting that Mexico, which was the first country that the United States tried to set an agreement with, didn't agree to these same kind of things. They did not agree to a return policy. They have acquiesced to the migration protection protocols that remain in Mexico, but they have no responsibility to actually accept those asylum seekers or for them to take asylum in Mexico. Mexico does not believe that those are people they will eventually have to be responsible for accepting or deporting, that the United States eventually will let them through their process and then return them back to their own countries. So Mexico did not agree to any of these same kind of things that these Central American countries did, even though the United States apparently really wanted them to. So again, figuring out this process of when somebody arrives at the border, what happens to them, where do they go, is still a little bit muddled with all of these agreements that are out there.
All right, in a moment, Litigation Corner. Stick around. Finally, today we're debuting a new segment here on This Week in Immigration. Litigation Corner, as we're calling it, will cover major developments in immigration policy lawsuits and provide quick analysis. For each case, we'll cover why the case is significant, what the judge or judges said, and what happens next. Okay, today we have 3 cases to review. First up, a federal judge in California stopped the Trump administration's efforts to eliminate the Flores settlement, which bars federal authorities from holding families in immigration custody for more than 20 days.
So this has been the Flores settlement, for those who don't remember, it dates from the 1990s, a settlement agreement that is the terms and conditions under which the federal government can detain children. During the Obama administration, the judge that monitors the settlement said that it also applied to children held in custody with their parents or in family units, and put a 20-day limit on how long they can be held in detention. The Trump administration has worked very hard to find a way around, through, or away from this settlement. And the terms of the settlement do say that if the government were to put forward regulations that implement the settlement agreement as part of the regulations, that the court could then end the settlement and the regulations would take precedence. So the Trump administration earlier this year did put forward its final regulations to try to implement the Flores settlement, but the judge overseeing it, Judge Dolly G., said, actually, no. These regulations are not good enough. They do not implement the Flores settlement in sufficient detail. And so she said that the settlement would remain in place and the regulations are therefore void. It was a rather short order. She simply said that the regulations do not meet the requirements to lift the settlement. And so therefore, I guess the administration has to either appeal this ruling, which I'm sure they are, or go back to the drawing board on their regulations.
I think the key thing for implications is obviously the administration has been making this a policy goal, as Theresa noted. They've been introducing a whole host of regulations to kind of address the situation at the border. So I think it's important to understand that this is just simply part of the rush to push out as many regulations to try to deter the arrivals of migrants. So obviously, while this is going to be an appeal, there's other policies that are, still much in effect, like the second so-called asylum ban that's been, impacting the ability of individuals to access asylum at the border.
All right, next, another federal judge put the brakes on regulations that would have led to nationwide expansion of expedited removal, a policy that would allow immigration authorities to remove more migrants without a hearing in the immigration court system.
Yeah, so this one is about expedited removal. As you mentioned, that is the process under law that allows certain individuals who have entered without inspection or have been found inside the country having entered without inspection to be removed without going before an immigration judge. The law allows this policy to apply to anyone apprehended anywhere in the country, but by policy, the administration previously has limited only to people apprehended at or near the border. This policy change would have expanded this to anyone inside the country who has been apprehended by Immigration and Customs Enforcement who had been in the country less than 2 years. The judge in this case said, put a temporary stay on this injunction, had questions about how it would be implemented, but most importantly, questions about the 2-year limit and how that could be applied and implemented, whether or not somebody would be able to prove that they had been here less than 2 years, and whether or not that would the government would have the ability to figure out who that was. So at least for now, this expansion is temporarily stayed. Again, this was a district court judge that made this injunction. So we'll have to see if it gets appealed. It probably will be, and whether or not that injunction will remain on appeal.
This regulation was introduced in response to, once again, sort of activity at the U.S.-Mexico border. And this is a temporary setback for the administration, but it is worth noting that prior administrations did explore this issue. But one of the reason why it hasn't been expanded was less so for legal reasons, more the fact that ICE and CBP just didn't get along, and the implementation of nationwide expedited removal would have placed a lot of burdens on ICE in order to implement it.
Okay, finally, a federal court in California prohibited ICE from using federal law enforcement databases to issue detainers for non-citizens in county jails, which impacts the operation of the Secure Communities program.
Yep. So Secure Communities, who some call SCOM, was this program that was started in the George W. Bush administration, expanded under the President Obama term, at least during his first term, then ended by President Obama in his second term, replaced with something called the Priority Enforcement Program, or PEP, and that Trump reinstituted. Secure Communities is the ability of ICE to obtain from the FBI notification when non-citizens are booked into local jails. When a non-citizen is booked into a local jail, that local jail sends their fingerprints to FBI to get their so-called rap sheet, their history of arrests and convictions and priors. The FBI then shares those fingerprints with ICE, which checks their databases to see if that person might be removable. The implementation of this particular lawsuit in California was about the fact that ICE would issue detainers, that is, requests for local law enforcement to hold people as a result of these database checks without confirming whether or not the person in custody actually was the person that ICE thought they were, that they were a non-citizen. They were issuing the detainers strictly based on these database checks. And the court in California ruled that that policy of issuing the detainers only on the basis of database checks was not sufficient probable cause that this individual was removed. The case was brought because of a U.S. citizen who was detained improperly based on one of these detainers because his name was incorrectly found in ICE's databases. So this ruling stops the implementation of this type of detainers being issued in California. But furthermore, the portion of ICE that does this database check both in California and after hours in other parts of the country is located in California, so it impacts other parts of the country where they're issuing detainers based on the results of the database checks from this California bureau. It also would restrict the usage of these in localities other than those that have agreements with ICE for detainers, like 287G agreements.
This is actually probably of all these decisions the one that I think has the longest term impact, because this has been one of the principal ways that ICE has been able to sort of find individuals who violated the INA, detain them, and sort of deal with them. So the question is this going to be the beginning of similar restrictions in other parts of the country? And that's something that we need to pay attention to moving forward.
Yeah, I think of the three that we talked about today, this has probably potentially the biggest impact on interior enforcement, probably even bigger than the expedited removal case, because secure communities has been the primary way that ICE has targeted and detained immigrants inside the country for over a decade now. They have been complaining for quite a long time that sanctuary policies have limited their ability to do this. This ruling would expand the limitations of secure communities beyond just sanctuary communities, so it can have a big impact.
And that's Litigation Corner. We'll do it every time there's major legal news to round up. Theresa, Cris, that's a good place to leave it for this week. Thanks for joining me. We'll be back in 2 weeks. In the meantime, please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, Spotify, or wherever you get your podcasts. Just search Bipartisan Policy Center. This episode of This Week in Immigration was written by Cris, Ramón, and myself and produced by Ifat Tawahara. That's all for now. Join us again next time on This Week in Immigration.